Welcome to the Legal Services Clinic. We will explore the key areas such as fee disputes, coverage gaps, ethical compliance to safeguard your practice, reputation, and operations. Through engaging discussions and real-world examples, we'll examine the critical elements of effective risk management, including clear billing practices, robust coverage, and thorough client communications. This class offers practical insights and actionable tips to help you navigate the complexities of legal malpractice prevention and ensure your firm's success and stability. Without these proactive measures, even the most well-intentioned practices could face unexpected challenges and liabilities. With over a decade of experience in mitigating risks and managing claims for these industries, Edita has become a recognized authority in the field of malpractice, errors, and omissions. She successfully managed and resolved numerous high-profile claims involving invaluable risk mitigation strategies for legal professionals. A speaker and consultant for industry conferences, sharing insights on reducing liability and protecting professional reputations. Edita has been an advocate for continuous education, completed advanced courses in risk management to stay at the forefront of the industry. She is also an accomplished pianist and with a deep love for music. In 2012, she was a USA Adult Figure Skating Champion and gold medalist. So, welcome so much, Edita. Thank you for joining us and trying to reach out to young lawyers who will be listening to and watching this video on how to avoid malpractice. There are lots of issues that we brought up about billing, communications, etc. But I'll let you take it from there as to how you perceive the practice when you insure agents, lawyers, and what they should reach out.
Thank you, Anthony. I appreciate all that introduction.
Okay.
So definitely I want to go over the strategies that you can use because leading the company that focuses on legal malpractice, I have seen the claims and I have seen what some attorneys could have done to prevent themselves from this legal malpractice. There's definitely a lot of strategies in place that you can do that you might not think about as you're busy running about your day. But there's definitely quite a few things you can do that can mitigate those risks, and I'm hoping that by the end of this course you will feel a lot more prepared to avoid these mistakes and these risks. So to make it a little bit more successful, I think that it will be very useful to have your participation here a bit so that these things are more clear and so that hopefully you can retain some of this information. So with that, I would like to start with the first question I have is, what do you think some of the main legal concerns could be for an attorney? What could be some of the main causes of malpractice? Would you be able to get some info?
Client communication, usually the lack of communication or the kind of the devolving of first initially signing up a case and then not having that consistent back and forth with the client makes them feel like you're not working on the case. So I'm sure a lot of claims are based on the idea of failed communication between client and attorney.
Yeah, definitely.
Before you start answering the question, please repeat the question because it may have it recorded. So repeat the question that you and answer, okay?
Okay. Yeah, so we're looking at what's your biggest malpractice concern? That would be the question for the audience, and some of the answers here that we received is the lack of communication, and that is absolutely one of the big ones, definitely, especially with the beginner attorneys. That's definitely a case with the ones that just starting the case because they're not very savvy on engagement letters, disengagement letters, fee disclosures, or transparency. They might just have a little bit of lack of experience, or they might have a little bit of a concern of how that will be perceived, but that communication can absolutely help you. Are there any other things you can think of that could be malpractice concerns, perhaps?
Let's go. You mentioned something in the question. engagement letter. Let's talk about a little bit about, because a lot of lawyers start off their practices not knowing first how to distinguish a good client from a bad client. Client expectations. If you have a client expectation and you don't know how to control that expectation, it becomes a problem because you'll never get satisfied. The engagement letter does what?
So engagement letter will clearly define what your fees are, what your expectations are, what your services are, and this engagement letter likewise will show you that you finished your job with the client. Now, when that is extremely important is in the situation of, for example, conflict of interest. If you are having another client and there is a conflict of interest, and if you are not doing your due diligence, understanding that there is a conflict of interest, and if you do not have this engagement letter, you're putting yourself at risk for malpractice claims. Now, you would have to get a waiver from the previous client. You would have to have a disengagement letter saying that your services are completed with the first client before you would be able to take on the new client. So that is absolutely one of the risk mitigating strategies. And I will also touch base a little bit, but let me go ahead and give a brief overview of some of these items that I wanted to go later in the course. So definitely engagement, disengagement letters is one of those, and client communication was another one. We have missed deadlines, we have conflicts of interest, we have fee disputes, of course, client misunderstanding of outcomes, cybersecurity breaches, lack of expertise in a certain area, failure to meet client expectations, ethical violations, some of those that I have previously discussed and heard that attorneys would communicate back to us. So I wanted to go ahead and perhaps start with the number one, something that every attorney has encountered at least once in their experience, and that would be the fee disputes. So I'm not sure how many of you might have experienced it and if that went smoothly or not, but that is definitely one of the number one risks for malpractice claims.
One of the questions that I always, when I fill out my application for malpractice, they ask me, have I ever sued a client for fees?
Yes.
Why does the insurance company ask me that?
That is an excellent question. So just to repeat, the question was every time you do your malpractice application, because you have to complete that once a year to get your malpractice policy, there will be a question how many lawsuits for fees you have had or you have per year. And the answer here is a twofold. So, and I'll answer it on both ways. So if you are not getting paid, and obviously you want to get paid, and you sue your client for fees, what do you think will happen next, or what your risk becomes? The risk immediately is a countersuit. So you're putting yourself at risk for a countersuit immediately. And of course, a countersuit, even if you don't think you're at fault, can have quite a bit of consequence for you and for your bottom line, especially in malpractice policy. So for example, you sue the client, they sue you back because they're not happy with your services. And now you have insurance company defending you. They do have to get an attorney. They do have expenses. The next thing you know, the lawsuit perhaps is not going anywhere, but you're looking at your loss runs report and they've spent $11,000 defending you. Now you have a lawsuit on your hands and your price will go up. And so your liability goes up and your ability to find a good carrier, a good price goes down. So there's definitely a consequence. So before trying to sue your client, see if there is a way to figure it out. Also having very clear understanding of how much you charge and why upfront. It is very, very important. That is another thing that some of the young attorneys do not do, as they're afraid to charge a high fee, so they put a really low fee in the beginning. The next thing you know, there is an email response, a phone number response that was not disclosed, and they say, well, I need to charge for this. And the client is not aware, and they get a bill and they say, why is that? So also coming back to the insurance application, if you will put more than two, your pool of choices will go down. So from insurance carrier's perspective, your risk is much higher if you are having 20 lawsuits for fees per year as opposed to 2 or under that. So if you have a lot of suits for fees going on every single year, you are a high-risk attorney. And so they know that they will have to defend claims and they will not want a high-risk attorney on their book of business. So that is definitely something to keep in mind. And so the countersuit, obviously a big one. Another thing, I said the answer is twofold that you might want to look into. Some policies will have coverage for lawsuit for fees. That is not the primary goal of malpractice policy, because clearly you're not making a mistake here. You're just trying to get paid. And it is not a perk that a lot of policies do, but it's a fantastic perk to have. Because if you do not get paid, the policy might actually pay you for it. So some policies will have that as a separate perk, which I think it is a really, really big benefit to have in your policy if your carrier offers that. So that's something to take a look at. So that's number one item I really wanted to go over, which is the lawsuit for fees.
There's there's a company out there now that is offering to finance client fees. So if you have a flat fee of $10,000, the client is supposed to cannot afford the $10,000. The company will lend them the $10,000. They pay the lawyer, and then the client has a loan, sort of like financing. Now, of course, now there's a disconnect between the loan and the lawyer. At this point, the lawyer says, you know, if you have a problem with the fee, collect it from the lawyer. I would collect it from the lender, from the bank. Yeah. Is that an ethical problem, or is that covered? You know.
I have never heard of this. To be honest, my understanding is that it would require a little bit more. I don't see why not. I mean, we get finance for a lot of things in general. When we look for services, we finance the policies as well. I do not think that that's a conflict of interest, because you are basically passing down the risk to the financing company. I would just be curious to see what the consequences are if they don't pay them. Because as an attorney, I would not want to come back and be dinged for it at the end. But I think that if there is a way to transfer that risk, then probably partnering up with a company that provides that to the client that is reputable might be also a good strategy to mitigate your risk for not getting paid. So
you have a question?
Yeah,
Speak up so we can hear you.
Okay, you spoke about your renewal application, which, if my experience is that the initial application, what are your responsibilities as far as researching your practice areas, your former cases, and disclosing all that on the initial application? Because I feel like when you're doing these applications, you may not recall everything that you do. Or maybe if I only touch one probate case every year or two, how am I supposed to disclose that to an insurance company for coverage?
Yeah, so good question. So there is usually, every application has a grid. And on that grid, you would put a percentage. I typically say put at least 1% in the area that you might work or might have worked in the past. That will give, you will be protected for it if you have at least 1%, if it's really minimal. And of course, you can put a higher percentage on your primary area of practice. However, it is something very important to do for the reasons that some carriers specifically exclude certain coverages. Now, usually, if let's say you did one wills, estates, and your case, and you didn't have that on your application, they typically still have a duty to defend you. But there's a problem when some carriers specifically do not like mass tort or class action, intellectual property, medical malpractice, all the high risks, and they say we just don't give this quote at all. And you don't have that at all on your application, and then a claim comes in and it is in mass tort, you have a risk, because they will say, well, it's not disclosed. And those particularly very high areas, high risk areas, my recommendation is, and I've had clients call and say, look, I'm about to take potentially this case. I want to make sure that my carrier is okay with it, because it is so out of the ordinary. But typically on the application, there is a grid that lists most of them. There's even an area for other, because sometimes, let's say, workers' compensation might not be listed, or Social Security might not be listed. If you are into like a little bit more ad hoc type of areas, you might need to put it under other, but disclosure is always the best way to prevent from having any issues in the future. I typically say for one type of case that you mentioned, put 1% in that area and you will be fine. Yeah.
Well, that question leads us into a segue, which is perfect, because you have a new application versus a renewal application. When you switch companies, carriers, that is a new application, but then how does the coverage work from the last coverage that you had to the new coverage?
Excellent question, because that's also my second point of malpractice risk right here. And this is the retroactive date and the coverage gap. And I'll address your question in just a second. I will kind of ease into your question with the two applications. Retroactive date is something that I have some excellent attorneys that are just really excellent and really successful, and they just don't have time to look at the details of the policy. Insurance is not something that is on our mind, or their policy is not something that is on our mind, and they don't really look at those details. But this is such an important detail that can have very, very large consequences. When your agent starts soliciting you for renewal application, when they call you and they say, I need it, I need it, I need it. The reason is not just because they want your business. The reason is that if you do not renew, you have a potential to lose all of the coverages you paid for before. Even if you don't renew for 1 day, that risk is there. So any gap in coverage will make you lose your retroactive date. So I'll give you an example. If you start your policy paying for it in 2010, and that's your first policy, and that is called your retroactive date. Let's say January 1st, 2010 to make it easy. That's your retroactive date, which will be listed on that first policy. That's when your coverage starts. Nothing prior to that will be covered. If you continue your policy and now we're in 2024, technically, if you look at your policy and you look at your deck page and you find retroactive dates, which will be listed on every single policy, you should still have their retroactive date, January 1st, 2010, even if it's a policy right now. So that date must carry over and over and over from every application, regardless of the carrier. So if you're switching carriers because you find a carrier, your carrier has increased the price, maybe they're no longer so competitive and you've switched to a different carrier, make sure that retroactive date has carried over, because that retroactive date shows how far back you are covered. If this retroactive date for some reason is not there, you have no coverage going back. So on the application, one of the questions will always be your retroactive date, because it's only the final policy that will cover you. Nobody is going back to look who you were with 10 years ago. It's your final policy that will be the policy that will take care of your claim, and that's who will go to see how far back. So they take up all of that responsibility. Now, when you do an application, the first application, obviously, you put your whole information because the underwriters need to see all of it. When you renew, if you renew with the same carrier, a lot of times they send you 5 questions. Have there been any changes? No changes, because they already have that. Or maybe you say this changed or this changed. So they have all of that on file. But if you want to switch to the carrier, they will need to see that new application again, because they don't have those details. But the retroactive coverage on those applications has to carry over, and it is your responsibility as well as your agents to make sure that it carries over. So I will give you a good example of what has happened in the past. There was an attorney, 2-attorney firm with one of counsel, and they were paying about $4,000 for the policy per year. And they got another quote for $2,000. And they kind of briefly looked, the limits are the same, and it's half the price, looks good. The agent did send that quote and presented it and put retroactive date, RDI. Now, to the attorney, it means nothing. RDI, what's an RDI? I don't know, and they did not ask, but the agent says, well, we put that on there, so you should ask if you're not, no. So I think it is an agent's fault for not going into the details, what does RDI mean, but for attorney that is watching for this, I think if you don't see 1/1 of 2010 on there, that's a big problem. And so RDI means retro date inception, which means from today going forward. So
that'll be clear. So let's say in 2010, you had a policy, and in 2020, you changed, right? And you have an RDI on that 2020 policy. Something happened in 2015, now they sue you for the action in 2015, you would have no coverage.
absolutely.
Okay.
Which means RDI means you are only covered brand new. You're just going from now going forward. So in this situation, you really putting yourself where you're throwing money out into the garbage as well. So some of the times when this mostly comes into play is if people have claims. And that's where the situation comes that perhaps you're with an agent that does not have a lot of access and they just can't find a quote for you. Because if you had an $800,000 claim, it is very high possibility that a lot of carriers will say, I can only give you a quote RDI. Basically, I'm not going to cover because I don't know how risky you are. I can only give you a quote going forward, but I'm not picking up all of these years of coverage for you. But I would get a second opinion because a good agent will always get you a quote. It might be more expensive, but you should have that choice to make that decision. Because I've seen people with $800,000 claims and they still have an option of, okay, here's $5,000 because your price will increase after a large claim for sure. But you should be given a choice, $15,000 policy with the retro or $5,000, $6,000 policy without the retro. I will always push to keep the retro just because if you had one claim, sometimes there's some things that are similar mistakes in the case, and having that retro is very invaluable in my opinion. And keep in mind that the price jump after a claim only stays for 5 years. So yes, and so kind of slowly goes down after that first year. You can start seeing a little bit, and it goes back after 5 years. It falls off your history, and you're fine. You're back to where you started. But the retro date, it is very important. Another one very important aspect I wanted to touch base of, which is a little bit more detailed, but we've seen this situation at least twice. So it's very important. If you reporting a potential, and we just touch base, reporting a potential claim to the carrier is highly important. Now, it will not ding you, it will not hurt you in any way. Reporting what they call in insurance terms a circumstance. If you don't report it, you put yourself in a situation where that claim might not be covered in the future. If you report it, it's a little bit more at the renewal. I mean, ask some more questions. They might ask for loss runs to confirm they haven't paid out anything. But reporting it guarantees that they know about it and you have that coverage. And so...
and that's because, Edita, your policy has a clause to say that if you have a potential claim, you must disclose it.
You must disclose it within a reasonable amount of time. Now, every policy will have a different time frame. So for 2 reasons, you must disclose it. Number one is you disclose this exactly for that, because the carrier says, if you, and I gave that example before, if you get an email from the client saying you did this mistake and I'm going to sue you, and you don't tell insurance carrier, and you don't do anything because thinking, well, he's crazy, or I'm not, it's frivolous, he has no case, and you don't do anything, and 2 years later, he decides, I'm not sure what the statute of limitations might be, but let's say 2 years later, he's able to go ahead and sue you for this. And in the paperwork, the carrier sees that 2 years ago, he sent you an email, you did not disclose that to the carrier, and you renewed your application twice. And on the application, you have to put on there, are you aware of anything? And you said no, but you got an email from the client. So that basically disqualifies your entire application, and they have no reason to cover anything. They can disqualify your entire complete coverage saying that the application was misrepresented. That's number one. Number two is if you change the carriers at any point, which you can do so, that is not a problem to change the carriers for price reasons or better coverage or whatnot, or different limits, maybe that you need higher limits this carrier doesn't give you. It's fine as long as the retro is there, and as long as you report if there's currently anything known to the first carrier before you switch. It is highly important. So whoever you report it to, that's who is responsible for covering your claim. And so let's say there is an example, you are about to switch and you are aware of something, you will tell to this carrier, I'm aware of this, you send an email, this is the circumstance, it could turn into a claim, they're on the hook for it. Then coming to the new carrier on the application, you will say, yes, I'm aware of it, it has been reported to my previous carrier, and you switch. So you disclosed it to both, and you ensure that this claim will be covered if something were to happen. Well, we can never say it will be covered because there's a lot of other exclusions and things, but you do the best you can to protect yourself. And we've had, again, the situations that we've seen, huge claims come out of this where a client thought it's frivolous, didn't report it. Switched the carriers on the application, didn't report it because it's frivolous. Actually, in fact, their attorney told them not to do anything because it's nothing. Their attorney of the title firm told them it's nothing, they have no case, we don't need to do anything, they have no case. So they didn't report it to the current carrier. And then they switched to another carrier which was cheaper, so they were able to save some money. And on the application, are you aware of anything that could lead to a claim? They said no, they got a new carrier. It ends up going into a claim.
Right.
Now, we report to the old carrier and report to the new carrier, and they said their attorney was advising them. So that's attorney claim as well. So he's putting himself a malpractice risk right there. So we reported to the first carrier, and the first carrier said, well, it was never reported to us, and now we're off the hook because we're no longer on the policy. We're off the hook if it's not reported. The new carrier says it was not reported on the application, and also it happened, before we took over, we were not aware of it, we're not covering it. The client is without the coverage.
I think it's important to point out, so just in case everyone's clear, your malpractice insurance covers the defense as well as any potential loss of claim.
Indemnity.
So that's important because otherwise you would have to defend yourself
Yes.
or hire a lawyer to defend you, which is a cost, plus whatever payout that may have been. Right? Is that correct?
Absolutely. So you have two buckets in every policy. You have claims expenses and you have the indemnity payout. So claims expenses, even if you're not at fault, you will have claims expenses because they will defend you. And so you might win, and you might be found not at fault at all, but you might have $11,000 claim because they've paid expenses that will be showing up on your report for insurance purposes that you have had. It's not a true claim against you, but it's claim from insurance standpoint. So there's those two buckets, and then if you're awarded another how many thousand to pay because it is actually your mistake, then they'll pay that from that bucket as well. And so that is correct. Yes.
So which leads you to another question. Okay? Let's assume, well, what happens, there's a claim against the attorney, and he makes a claim, he informs his carrier, the carrier assigns an attorney to represent the lawyer. Then there's going to be, like every case, a negotiation. Mm-hmm. Who has the right to settle? Who has the right to finally say, okay, let's settle this case?
Yes. So, again, good question. So the insurance company will always try to say, can we have that right to advise you? Sometimes they will offer perks and things to you for an ability to follow their lead. Sometimes they'll waive the deductible. They'll have that conversation with you if they don't want to, let's say, litigate, and if they want to settle but you don't. They might actually go ahead and offer, some things that can benefit you for following the lead, but you as an ultimate client, you can always say no. There are some policies, this is where you have to see, that will hurt you if you want to continue litigating after they say we recommend you don't. So there are some policies that will say we are not going to cover you or those litigation expenses if you don't follow our advice. Now, this is something that every policy is different, but this is definitely in each of the policies. There's either you don't get punished for continuing litigating, or you do half. It could be like a half punishment, like 50% will pay.
Okay, so this is very important for all of you practitioners out there to know that when you buy insurance, you're buying it for the purposes of getting the defense and any particular claim they may come out of defense. You also may have the right to decide to settle a case or not, because there could be a situation you don't want to settle because of the impression that it might give in your practice. oh, I committed a malpractice when when I represented a high-profile client, and that could possibly ruin your practice. So you don't want to settle. But however, the insurance company wants to get out of this thing, and they want to settle. So the question is, does your policy allow you to fight to the end, or will your policy say to you, this is how much money we're putting on the table, and after that, you're on your own? Correct?
Absolutely. And at the same, on the same topic, are you allowed to choose your own counsel? Because that is another thing. Sometimes you are, sometimes you're not. Depends on the policy, depends on the carrier you're with. Some clients I've had where they wanted to have their own counsel. Now keep in mind that insurance companies have a lot of claims. So they really have good attorneys that have a lot of experience in that particular field. So I do always recommend going with them, but we've had situations where clients wanted their own. And in that case, you have to see if your policy allows for it or not. But often you can recommend your own counsel, and they will review their experience and expertise in a field, and they might agree to use them for your defense or likewise. So this is all in the policy. Like I said, every policy is a contract, which is different. So it's something that it's a conversation with your agent. Which leads me to my next malpractice prevention strategy, and that would be disciplinary proceedings and ethical compliance. And so disciplinary proceedings is another thing that is in your policy. You either have it or you don't. And you might not know, but I've had attorneys that had disciplinary proceedings with the board and got a refund check for $10,000 to cover expenses that they had for disciplinary proceedings with the board. So it is a very good additional perk to have on your policy. But not all policies have that, but it is very important to have. So I would check your policy if you have coverage for disciplinary proceedings. A lot of times the fines are not covered, but the defense is. So the research, the defense, helping you figure it out is covered, but the actual fine is typically not. So we're also looking at I want to talk a little bit about the ethical compliance as well. We can, I have an example for you. We have, if you have a client that you are representing, and let's say it's a family law, you're doing a divorce case, and a client in private explains to you that they have some hidden assets, and they are asking you not to let anybody know, and you have the client attorney privilege where you have an NDA and all of this, so you cannot disclose this, right? And they're telling you they don't want you to disclose. But now you get from the spouse's attorney, you get a letter asking you for all of the financial information. My question to you would be like, how would you handle that?
Well,
How would you handle that situation? Because the other attorney is asking you for financial information, but your client, and you have an NDA, is asking you not to disclose the hidden financial assets.
do you want to answer it?
Anybody?
Well, if it was me, I would be asking the client for all the records. I would say, we received this request from your spouse's attorney. It's asking for this, this, and this, tax returns, bank accounts, and everything else. And if it comes back to me from the client on what they choose to produce, not covering everything, I would advise them that they're exposing themselves to a big problem, and they're maybe placing me in an ethical conundrum.
Absolutely.
Because I know there's another bank account that they don't want me to tell you about. I know there's another business out there that they don't want me to know about. And usually in family law, the spouse knows if there's something else out there, and they go looking for it without any disregard. So hiding it after the fact is usually poor judgment on the attorney's part. That I don't know about an ethical problem, but it certainly would be a concern as the divorce litigation devolved.
Yeah, so this actually does fall under the ethical compliance for an attorney, and they would have to explain to the client that they must produce those documents and that it puts you at risk, and it absolutely does. For ethical compliance, and so you would basically, if they decline, your responsibility would probably be to withdraw from the case and not to continue. Now, if it turns into the claim your policy will not cover it because you violated ethical considerations. So your policy will not cover something where you've acted unethically, and this would fall under one of those categories. So this is very important that you put yourself, keep yourself for the utmost ethical compliance there, because your policy specifically exclude usually ethical considerations, unless once in a while, if you contact your policy carrier and let them know this is the situation I'm at, like I said, that notification makes a big difference. They might have the defense for you in that case if it came out as something because you notify them of it. But if you don't, most of the time you will be in a situation where you do not have the
This
coverage.
is where a situation you could have where you also have a question of protecting the client from criminal liability. So if the client discloses, if they disclose, and that could be getting them in trouble on a criminal liability issue. So at this point, you're talking about taking the Fifth Amendment or clausing, protecting your client under a criminal statute of the Fifth Amendment. So protect them out, because if you don't, if you just disclose,
Yes, you can't do
then
that either.
you're committing malpractice
Yes,
the other side.
exactly. You can't just disclose this because your client is telling you not to, and you can't go ahead and disclose something that's, under the, exactly under the law. So you're in that situation.
Those
where-
are really touchy situations that every
Absolutely.
lawyer is going to, particularly in litigation where in matrimonials, those are very particular. That's why I don't handle matrimonials.
Yeah.
But those are ethical questions which become very tricky, and particularly for those lawyers who have the couple came to them because they know them already. You may have found yourself that you have your best friend, your golfing buddy is the husband, but you've been to the guy's house and you know his wife, and then all of a sudden you've had some discussion. You just open yourself up
Yes.
for an ethical consideration,
Yes.
an ethical charge on that.
Yes, good point. So keep that in mind. Have that always in the back of your mind that this is something that is not covered by your policy. So don't put yourself in that situation where this could be a risk for you. I would like to go into another interesting risk management strategy here. And the reason I say interesting because it's a little bit sneaky the way it is being asked on your application. So you will get this question that says staff to attorney ratio, or how much staff you have, how many attorneys and how many staff, or what's your staff to attorney ratio. Why do you think the policies are asking you that?
Well, obviously that question is dealt to find out whether you have enough staff to handle the volume of work that you're doing.
Well, in fact, it's the opposite. They don't want you to have too much staff per attorney. And this is where the tricky question comes in, and this is why it is a tricky question. So if you have, and the threshold for most carriers is 5 to 1. So you don't have to have more than 5 staff per attorney. And it makes sense because if you have 20 paralegals or staff working on your cases and it is just one licensed attorney, probably you're not supervising much. And if you're not supervising much, you are a risky client because you're opening yourself up to potential claims. So if your staff to attorney ratio is already 5 to 1, the consensus is that it's better for you to consider hiring an attorney instead of more staff, and then add more staff as you go. The reason for that is that you just need that supervision from a licensed attorney. You know how much education you have had to go through, and they haven't. So you understand a little bit more you need to supervise, especially the young junior staff that just comes in, because we've definitely seen situations where there's a lot of mistakes come from that side as well.
Yeah, and we have, there are certain areas of law that you may be practicing, whether it's personal injury or collections law, for example, where it's really turned over, it becomes administrative. And if you have a lot of staff that are delegated and basically become like an attorney, because they're either settling cases or they're filing the forms and they're acting defenses, and you don't have enough, you're dealing in volume in your practice, that's likely to have a situation where you can have a claim.
Yes, yes, absolutely. So keep in mind the staff is important, and keep in mind that 5-to-1 ratio, because that's what the carriers will look for. And if you put more than that, chances are, because when we shop for quotes, what we do is we get a lot of them. The more quotes we have on the table, the better the price and the better the coverage you have, because we have a pool of options. If we only have one, then there's not a lot of options for you to get the best choice out there. So if you put 6-to-1, a lot of them will say, no, 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 no. Now we only have 3 quotes, and they're more expensive as well. So that's something that protects you from malpractice, and is something, the number to kind of keep in mind. We've already touched base a little bit on managing conflict of interest, but that is something that you definitely have to do your due diligence, to do a lot of documentation, a lot of research to make sure there is no conflict of interest. That is a big malpractice claim trigger. Right there, engagement, disengagement letters is something that is very important in those type of situations. There have been some very high-level claims arising from the situations where there's a conflict of interest between the two parties. So doing your due diligence of researching, if there is one, is a good place to start. Because once you have that, then the best things to do is make sure you have disengagement from the former client, make sure you have a waiver, potentially as well. And if you can get that waiver, letting them know that now you will be representing a new client, that, if you don't have these waivers and these documents in place, it's the best to withdraw from the case altogether and not take that new client to protect yourself, because it can be a very costly mistake for you. Do you have any questions, or can they keep going?
No, I mean, they're in conflict of interest in criminal cases, just to take it aside, because my good portion of my practice has been in criminal law, and when you're representing 2 defendants in the same case, you're automatically thinking conflict of interest. Is there conflict of interest? Because in most federal cases, certainly, but in state cases as well, sometimes the state will offer a better negotiated deal to one party if he testifies against the other, that it automatically puts you in a conflict. Now, there's a very elaborate procedure in courts. The judges will go and ask the questions of the lawyers and of the defendants, are you willing to waive? And then you'll seem to be protected, at least within the law, for the question of appellate review. But I'm not sure what happens with the insurance policy, should one of them decide to sue you anyway. But it's going to be an intelligent waiver on the part of one of the persons. But what is, in criminal law, is clearer where the conflicts could be. But how much conflict is conflict? I can see that there might be a question as to, do I really have a conflict?
Yeah, so if there is an interest, and any sort of financial interest from former party to the new party, that's usually a conflict. So a lot of times in the real estate transactions, you will see that you were representing a developer, now you're presenting some sort of buyer that had dealings with the developer in the past. That causes a lot of times issues. So anytime there is some sort of financial gain or transactions between the two parties, a lot of times that is a good
So that would
place.
be the metric. Is a financial claim or financial interest of
Yes.
one that comes
Yes, a lot of
against the
times.
other? Okay.
That is correct. Another item I really wanted to touch base on is the calendars and deadline management. And you probably all know statute of limitations, how you can lose your case before it even starts, right? If you miss a deadline, I mean, it can be just thrown out. I've had an attorney that hired an older attorney, 70 years old, because they felt, the person was, said, look, I'm retired, but I would like to do some more. I'm a little bit sad that I'm not in the business. So he hired this attorney to help him out. And he was there only 3 weeks, and then he left, and he missed 4 deadlines. And now the attorney is in a position of having to file the claims, because the claim is against the firm, and so it falls into his malpractice. And he had to file 4 claims or potential claims to the insurance carrier after 3 weeks of just 3 weeks of somebody working for him that he did not supervise, and that was 4 missed deadlines. Now, missed deadlines is big. So again, on the application, on malpractice application, they will ask you about your calendar system. They will ask you about dual person reviews. So it's not just a question because Like, it's a question that matters, because if you have a notification on the computer but also on a phone, it's kind of like sometimes we miss a meeting and we snooze on the computer, but then your phone dings and then you get to your meeting. But you can miss that. So having dual calendar system that notifies you of those major deadlines, those major dates is very important, and having another person that also keeps track of it, that can remind you, because you can, what we call it is lose a case before it starts, just by missing the deadline of when you have to submit something at the courts.
Could you tell us, remember, you're talking probably to a lot of newers, explain what is the dual calendar system?
So dual calendar system is nothing much more besides having two ways that notify you of the dates. And so if one malfunctions, you have a secondary, and it can be anything. It can be calendar on the, it's just you have two calendars that notify you. And so it's very important also on application that you check mark yes, because you will have a better rate, because you are lower risk. Or having a dual person checking important deadlines. If you have an assistant that she has a system in place, so you check the deadlines, but she does as well. It's very helpful for you as well to have that in place. So it is something so simple to implement, and sometimes I think it's really not that difficult to have a notification on your phone, but also on your computer. But it can make a big difference in the long term for you, especially with attorneys who have so many deadlines. You have so many deadlines with the courts, with the clients. You have a lot of things by when you have to submit documentation and things like that. So the next item I wanted to touch base off is continuing education and training. I know it's a pain. There's a reason for CE courses, but try to pick something that is useful for you, something that will benefit you. And there have been so many changes. I mean, we're living in the world of technology nowadays, in the world of innovation, and you're putting yourself at risk by not being on top of this innovation. Your risk of malpractice goes up by not being aware of what is going on and on the new things. So it's important to stay up to date. For example, texting. I mean, some attorneys use texting to communicate with clients. What are the issues and regulations about that? What are the issues and newest regulations in your state for reply to all on the emails? What are regulations on usage of AI? What are the disclosures and regulations? If you are in some specific industries like cannabis law, changes every day. If you're not aware of it and you're representing the client, you're putting yourself on malpractice risk. So training yourself and your team, if you have one, it is very important to protect yourself as well, because these things, we see them, and so carriers will send you sometimes risk management letters. Take some time to read those, because they will put some of the most important changes out there. But we do see those come in all the time, and they talk about what do you do if you use AI? What do you do if you use ChatGPT? I mean, how much can you use legally? How much is allowed? How much is not allowed for an attorney? What disclosures you might or might not need to put? What are attorneys' responsibilities with reply to all on the email? What is your potential risk? I mean, we might not have thought about it before we use so much email on a daily basis. What is your responsibility for sending a text? You know, it's something that now we use with this information technology that is happening, but there are regulations around that. You might not be aware of it, but that is something that you must check for your state, and you must be on top of it. And CE courses is one of the ways to stay on top of these regulations, because you will have some options. So don't necessarily look at it as the necessary evil, but look at it as something that actually benefits you. So pick the courses that are beneficial for you, because they are. So that is something that I wanted to lead to the next item, which is very appropriate to lead to the cybersecurity threats, since we're touching on technology here, which is a huge topic nowadays. Every company is hacked, just some know, some don't know. So if they can hack NASA, they can hack you. It's unbelievable what I have seen in that field. in this field, I have seen a lot of claims. Your malpractice policy might have a small cyber, they call it network security. They put it on there as a perk to entice you to buy their policy. I don't think that it gets you much, because usually they put 30,000 limit or 50,000 limit. If you have a cyber incident, it's going to be way more than that. And they only put network security. So only if your network is hacked, they come into play. So I don't really think it is that great of a benefit. What I strongly recommend for attorneys is have a standalone cyber policy. I would not operate without a cyber policy for my business, and I don't think any attorney should. It is a policy that will cover you for a lot more. It will cover you for phishing, will cover you for social engineering, it will cover you for funds transfer fraud. If there are attorneys that have a title company as well, which a lot of them do, your fund transfer fraud, you can have up to $500,000 or up to $250,000 covered for fund transfer fraud. If your client calls and it's an AI-generated voice, or they send you an email from a fake email, which they can make it look like it's coming from your client, and they say these are wire instructions, and you have a title firm and you're sending the funds and you're sending $250,000 to the wrong account, and you can't get that recovered, your cyber policy will pay for that.
I know I can give some expertise here, because I also have a title company.
Yes. Mm-hmm.
And it is the number one concern. And so my professional practice insurance also has to have a separate amendment or addendum for title companies.
Yes.
It's a title practice. And because that is number one target now.
Title companies always have these. They do. And besides that, I work with architects, engineers, and attorneys mostly. Architects, engineers, they will basically have no operations because they see everything is down. And the guys are asking for, $500,000 to get your systems back up. And if there is no other way, the cyber policy will pay for that. To get you back on board, they have the business income reimbursement. So if you lost a certain amount of revenue, you can get that back. It is an incredible product, and some attorneys say they don't want that because I'm not exposed. You as attorneys, you're more exposed than anybody. If you work on, you have intellectual property, you have medical records of clients, you have such private information that if it gets leaked and the client finds out it's because of you, you will get sued. And a lot of times malpractice policy might not pick that up because it is not their problem. That's your responsibility to take care of your IT issues, and so cyber is a very good policy to have. Even a smaller cyber, if you can't, if it's very expensive, get a $500,000 limit, $250,000. It's better than having nothing. As I mentioned, everybody has that exposure, especially attorneys have that exposure. So it's not just IT problem, it is your problem. And so of course having multi-factor authentication important, having some sort of virus controls and things like this. But with AI happening right now and all the AI learning, these people can call you and sound like your daughter. So we are really exposing ourselves, and who knows how it's going to continue going, but it is definitely something to consider for yourself to protect yourselves, because the cyber threats are definitely real for attorneys.
They're very real, and because I've had personally a situation where someone pretending to be Chase Bank with the entire face of the landing page looked like Chase. Yeah. Okay, I have an IT person on my firm that I was able to discuss with them, and they immediately realized it was a false. Yeah. But yes, they had pretended, they had substituted themselves as if they were Chase Bank, and it's pretty scary stuff that can happen to them.
Yes, attorneys definitely are on the forefront. They sometimes will hack, and they just look around to see if they can exploit it or not. So a lot of times they'll leave if there's nothing to do, because that's how they operate. That's what we've seen. But if they see any sort of private data that they can exploit, and if they feel that they can do that, they will do that. So if you have any sort of proprietary information or patent information, something that if you're representing high-end clients that are doing, new businesses and incorporating something, that could be very big financial consequences if that data leaks. So having a company and a policy that takes care of your PR costs and sends emails to clients, cleans up your computers, helps you with all of those expenses, it is very vital. And before I forget, I also wanted to touch base on this title company as well, because not a lot of attorneys know that you can usually, if you have a separate title company, you can add it on the same policy. And we have carriers that add it for $500 per year. Now, it cannot be a really, like, if you're running title company and just have a small law practice, it's not a good fit, because you do want to have a title policy to protect yourself. But if you're doing more law than title, you can add the endorsement and just add another named insured. So it will be two names on your malpractice policy with kind of a rider, what we call it, or an endorsement, also insuring your title operations. Usually the clients will be shared, and usually the smaller, the title operations are smaller. That's why it's on the malpractice policy. Otherwise, they will want them separate, so they will ask the revenues and things like this. But keep in mind that the limits that you have are shared between the two. So if you have $1 million for your malpractice, and now you added a title firm, now you have $1 million for between them both. So your limits do not double. So it might be a good idea to increase your limits, because now you are actually covering two firms. So if you have a law firm, a claim under the law firm, and it's paying $500,000, you only have $500,000 left for law and title together. So the limits are shared, but it is a good perk to know, because some people don't know. And we've had people that had a law firm and a title firm, and they were paying $4,000 and $4,000. And then they found out I can add for $500 to my malpractice policy. That's big savings. And it's perfectly fine as long as you're comfortable with the limits, and as long as the title firm is smaller than the law firm. So
Edita, we're down to our last 10 minutes, okay?
yes, perfectly fine. And actually, I am down to everything here. The only thing I have left with the conclusion is a case study. So I wanted to kind of go over and present this case study and see what you guys might, what will you see from the presentation we've had. What do you see as the issues and what they could have done to prevent this from happening? So we have a law firm of Smith & Johnson, LLP, a mid-sized practice with 30 attorneys. They had enjoyed years of success without any major malpractice claims, which is what we hear all the time. I've never had a claim. They all start the call with this: I don't think I need the policy. And then they start with the same: 20 years I had no claims, I have a letter in the mail. So no claims, no major claims, nothing, 30 attorneys. However, over time, the risk management practices became lax. They no longer consistently used engagement letters. They did more handshake rather than written agreements and contracts. And their conflict checking system was outdated and manual. Additionally, some newer associates weren't fully trained on the firm's ethical guidelines or coverage requirements. A long-term client who was frequently in touch with various attorneys in the firm requested representation in a lawsuit against a former business partner. Unfortunately, conflict of interest with another client went unnoticed, and no engagement letter was provided. Midway through the case, the client was surprised by unexpected charges, which were poorly explained by the firm. Meanwhile, a junior attorney without close supervision missed the critical filing deadline due to an outdated calendaring system, costing the client the case. When the malpractice claim came, the firm was shocked to find that they had a gap in their errors and omissions coverage. A policy change 2 years earlier had inadvertently excluded some retroactive coverage, leaving the firm exposed. So here we have a lot of issues. Can you guys touch on some of them and what could have been done differently? Because now I believe that you're quite the pros in risk mitigating strategies.
Yeah, I mean, I think that you touched on the missed deadlines as, you know, a potential critical end to the case that has everlasting consequences. So I think first and foremost, you know, the responsibility for that and the liability side of that is unexcusable, you know, with missed deadlines. I think the fee dispute and the conflict of interest issues that you brought up there were very relevant and on point, given the fact that you had the former client, business partners, conflict check, a lot of those things that you mentioned earlier in the presentation, and as well as the retroactive coverage date being something that you have to manage your policy for. So that case study is very on point, given all the facts and discussion that we had today.
And the lack of engagement letter, of course.
Engagement letters, supervision
Yeah.
of junior associates, right?
That case study
So
had
we have-
about everything we just talked.
It had a lot of things, it had a lot of things, fee disputes, conflicts of interest, coverage gaps, and things like this. And to close this out, I just wanted for the key takeaways, I mean, I know we've covered a lot, and remember that proactive management of your risk strategies, it can make a world of a difference for you. I have just come back from the conference. I was saying I was just in Chicago, the insurance conference, the Plus conference and I spoke to all of these carriers that I work with. And I was curious, asking them where current claims are going, what are the highest risks, and the answers really surprised me. Because in the past, we've always had real estate, and we've always had mass tort, class action, medical malpractice. Those were the ones that nobody wanted, as they were high-risk areas. And now we have wills, trusts, and estates coming as one of the highest risk areas because of the baby boomers that are retiring or passing away, and we have these trusts, estates issues that are coming into play. So do expect that this practice area will go up in price on insurance quite quick, because the carriers have experienced a lot of claims, because the insurance company is a business ultimately, so they need to make money to continue being operational. Otherwise they have to exit if they're not profitable, right? So they have to make more than what they're charging, and they have to incorporate the claims, and they have had a lot of claims in the wills, trust, estates area of practice, and so the pricing for that coverage will go up. That's my anticipation in the near future. So if you are in that area, be prepared for that, that this is something that's up and coming. But besides that, I just wanted to say that no matter what area of practice you are, a little bit of a prevention can make a big difference. A lot of times, with those calls and the claims that I've experienced and I have conversations with, a little bit of proactiveness could have avoided the entire thing. And so just keep in mind, just stay alert, keep an eye out for these items we've discussed, and keep the claims away from your firm in somebody else's inbox. So thank you so much for your time. I really appreciate, and please let me know if you have any questions.
Thank you very much, Edita, for your participation here and part of this series of the CLE courses of the Legal Services Clinic of the Puerto Rican community here from Florida. And remember that Edita can be found. She's with the Professional Insurance Experts, and she is also a sponsor of the Legal Services Clinic and the work that we do here. So thank you very much. Please stay tuned to our website for the other CLE courses that will be available to you. Thank you.